Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. So this is the second part of a two-part, whoop-de-doo, series on Realtor antitrust concerns. Or considerations, I guess is what I'm calling it. But this is part two. In the first part, we kind of talked about antitrust issues, and I'd encourage you to watch that in relation to fee setting and some of those things that can be pretty easy for people to slip into in the industry as you're out networking and doing other things in your marketplace. So you got to be cautious. In this part, I want to kind of talk about a derivative of that and something that still invokes some antitrust concerns. And that has to do with competency and out-of-market problems. So again, this is these series are being pushed a little bit by some rumblings that I've heard around the state with regard to market and market protections and everything else. And you know, our world is getting flat, or has gotten very flat, with regard to technology and the ability to do business in different areas of the state, even different areas of the country. Although your license license law would prohibit that in most states. In fact, every state that I'm aware of. But with regard to doing business in other markets in your state, you can really do that. There's one license in Colorado, and that enables you to do transactions throughout the state. There's no limitations on the license. So we've limited that in a sense through competency expectations. And some of those competencies, this is related to Rule E47, I think is the rule. And I did a video, Legal Bites, some time ago on E47, which is a relatively new competency rule. And one of the components of that is having geographic competency. But as I'm out, and it's certainly important to consider, but as I'm out talking to realtors around the state, one of the things that I hear is well, this realtor or that realtor doesn't have geographic competency. They shouldn't be doing business in our marketplace. And I want to remind you guys that the competency rule is not yours to enforce. It's a real estate commission rule, and it's ultimately the commission's rule to enforce. If consumers are being harmed based on the fact that realtors or other licensees are doing business in markets that they don't have competency in, or don't have access to the MLS, or shouldn't be messing around in based on the fact that they don't have experience to be messing around there, then that is the Real Estate Commission's jurisdiction to enforce under their rules, not you as a licensee's jurisdiction to enforce or to take position on or to not want to deal with based on market protections or other concerns like that. So I want to encourage you guys not to merge the lines. If there are competency considerations, that might lead to consumer harm, and ultimately there may be some recourse for that if you wanting to file a complaint or make the Real Estate Commission or potentially even professional standards process through the Realtor Code of Ethics aware of those concerns in terms of dealing with the public at large. But what it's not there for is this kind of market collusion in this market, you know, we're seeing a lot of out-of-market brokers or realtors come into our market and try and do deals, and they don't know the market, they don't show up for showings, they don't do this, they don't do that. Those problems, if you are trying to address those through your relationship to, in most cases it's going to be the seller, then you have to be concerned about your own potential breach of fiduciary. In other words, the idea that somebody from market A is going to come into your market B and maybe ask you to do a showing for them, or maybe you've got to do a little bit of extra work because that realtor or licensee isn't familiar with your market, that's not something that necessarily you need to be harming your seller potentially by. In other words, don't breach your fiduciary obligation to your seller. Your seller doesn't care where that other broker or buyer is coming from. They want to sell their house. And so if you're sort of standing in judgment and raising concerns related to geographic competency at that time, you run a high risk of breaching your fiduciary obligation to your seller in the event that that's taking place. So don't do it. Or I'm hearing a little bit about markets that are saying, well, we're going to pay brokers from other markets a reduced commission rate. We're not going to cooperate with them in some manner. The Code of Ethics requires cooperation, and your fiduciary obligation to your seller, again, requires that you're exposing that property to the market, that you're willing to do what it takes to act in your seller's best interest. And again, the geographic concerns and competency and targeting or boycotting brokers from different markets is not something that you should be doing, particularly as you're representing a seller, unless for some reason or another it's at your seller's best interest. But I find that hard to believe in many cases. So anyhow, some best practices: don't do it, don't do it, don't do it. Geographic competency, again, is not yours to enforce. To the extent that there is consumer harm, then take care of your transaction, take care of your fiduciary interest to your seller, take care of your seller's best interest, and then maybe talk to your employing broker and consider if there's, to the extent that there is the potential or has been consumer harm because of a broker's geographic incompetency or other violations, then maybe consider going to the Real Estate Commission and filing a complaint or filing a code of ethics complaint or something along those lines. But don't be adjudicating that during the transaction or leading up to the transaction, or more specifically with regard to antitrust, participating in these sort of market exclusionary tactics that unfortunately I'm hearing a little bit more about, again, as our market and our world gets more technologically flat for people to access. So be cautious of that. As always, if you have more questions, you can call the Car Legal Hotline. It's available from 9 to 12 and 1 to 4, Monday through Friday. And we'll see you again on another edition of Legal Bites. Thank you very much.